24 minutes past the hour now. A federal judge in San Francisco has ruled that thousands of FBI's secretive requests for customer information are unconstitutional. The FBI sends those so-called national security letters to banks and phone companies and other businesses every year demanding customer information. The FBI sends those letters without any judicial review, and the recipients of the letters are banned from making them public. So it's a huge secretive proposition. Now, on Friday of last week, the judge ruled that the government has failed to show the letters and the blanket non-disclosure policy, quote, serve the compelling need of national security, unquote. The judge also ruled that the gag order violates the First Amendment. Fox News senior judicial analyst Judge Andrew Napolitano is with us now. This goes to the fundamentals of something we talk about around here all the time. What of your private information should be available to everyone?
Yes. I mean, after 9/11, the Congress enacted and President Bush signed into law the PATRIOT Act, and among many other changes to the law, it authorized FBI agents on their own to serve search warrants or subpoenas on custodians of information. So a telephone company, a computer provider, a hospital, a lawyer, a doctor, having someone else's information. They call that search warrant, which goes around the Fourth Amendment, which requires that only judges sign search warrants. They call those search warrants national security letters. So when the FBI comes calling to your or my computer server and says, here's a national security letter, we want Shepard Smith or Andrew Napolitano's records, they also say you can't tell them that we're asking for these records. In fact, you can't tell anyone because the statute makes it a crime for the recipient of these national security letters to tell anybody. That's the part that was ruled unconstitutional by this federal judge in California on Friday, because that runs up against something called the First Amendment, which says Congress shall make no law infringing the freedom of speech. So how could Congress make it a crime for people to talk about the government seizing private information without going to judges first?
This is a process that's underway now that we knew that everybody who was paying close attention or trying to knew after the Patriot Act was enacted would eventually go away. It was a matter of when we all settled down and remembered the Constitution. This has happened. There's much more to come, probably, right?
Well, the Patriot Act had a sunset clause in it after 4 years. That was extended another 4 years. That was extended another 8 years. So we're still into the period of time where the FBI agents have this authority. But parts of it have been declared unconstitutional by 6 different federal judges, and the federal government still uses it because, you see, if the custodian of the records, in this case a computer provider, doesn't squawk or complain, just complies with it, the person whose records are sought doesn't even know that those records are sought. So they're not even in a position to complain about it or challenge it before a judge. It is the rare custodian of records who says, you know what, I think these records are private. I think there's something wrong with this statute, and I shouldn't just hand them over to you. It is that rare custodian of records who will challenge them. This challenge in California had the result where the judge said, can't do this anymore. People have the right to know when their records are being seized, and they have the right to talk about it in public. So the statute is unconstitutional.
It's going to be interesting to see what all has been done without anyone's knowledge.
Over 350,000 of these national security letters have been served since 2011. You think anybody we know has been the subject of it?
I'm dreading it.
Yes.
Thank you, Judge.
Pleasure.